A family of 3 is sound asleep in suburban Atlanta. It's the middle of the night without any warning whatsoever. Their front door explodes inward. Flashbang grenades detonate inside the home. Armed federal agents storm through every room. A woman is dragged out half-dressed and held at gunpoint. Her boyfriend is ripped from a closet and thrown to the ground in handcuffs. Their 7-year-old child watches all of this unfold in sheer terror. And here's the part that makes this story absolutely unbelievable. The FBI was at the wrong house. They had the wrong address. Every single thing that family endured that night was a mistake. But what happened next is somehow even more infuriating than the raid itself. When this family tried to hold the federal government accountable in court, the government's lawyers stood up and essentially argued that you cannot sue us because our agents were exercising their professional discretion when they planned and carried out this operation. That argument that a wrong house raid is somehow a protected policy decision traveled all the way to the highest court in the land. And the United States Supreme Court responded with something rare, a 9-0 unanimous decision that sent shockwaves through federal law enforcement accountability law. Now, the 11th Circuit Court of Appeals has just reheard oral arguments in this very case, applying what the Supreme Court laid down in that landmark ruling. And what happened during those arguments reveals something fascinating about where this case is likely headed, and what it could mean for every single person in this country. Let's break this whole thing down from the beginning. Back in 2017, FBI agents were preparing to execute a pre-dawn raid on a home in a suburban neighborhood just outside Atlanta, Georgia. They had a warrant. They had an address. They had a target. What they apparently did not have was a reliable method for actually finding the correct house. Instead of following established protocols to verify the physical location against the address listed on the warrant, one of the lead agents plugged the address into his personal GPS device, his personal navigation unit. Not a department-issued system, not a cross-reference map, a personal GPS, the same kind of device that has sent countless people into lakes, dead-end roads, and wrong turns on family vacations. According to that agent, the GPS routed him to what he believed was the correct location. It was not. The GPS apparently pinged the wrong home entirely. It directed the entire tactical team to the residence of a woman named Katrina, who lived there with her boyfriend and their 7-year-old son. This family had absolutely nothing to do with whatever investigation the FBI was conducting. They were not suspects. They were not persons of interest. They were not connected to any criminal activity whatsoever. They were simply asleep in their own home on an ordinary night. When the agents arrived, there was no knock and announce. There was no polite request to open the door. The front door was smashed in. Flashbang grenades, which are designed to disorient and incapacitate through blinding light and deafening sound, were detonated inside the residence. The family, awakened in absolute panic, scrambled to hide. They ended up in a closet, terrified, not understanding what was happening to them. Agents found them there and pulled them out at gunpoint using a shotgun. The boyfriend was handcuffed immediately. Katrina was dragged outside in a state of partial undress, held at gunpoint in front of her own home. Their child witnessed all of it. It was only after the family had been fully detained and agents began searching through the home that one of them happened to notice some mail sitting on a coffee table. The name and address on that mail did not match the warrant. That was the moment the reality of what they had done set in. They were in the wrong house. They had terrorized an innocent family. The agents told the family they would come back to explain, and then they simply left. They walked roughly 3 houses down, crossed a street, located the actual target residence on the next block over, and executed their raid there. For this family, though, the damage was already done. The physical damage to their home, the psychological trauma inflicted on every member of that household, and especially the lasting impact on a 7-year-old child who watched armed strangers attack his family in the middle of the night. In the aftermath, the family did what anyone in their position would do. They pursued legal accountability. They filed a lawsuit against the federal government under something called the Federal Tort Claims Act, commonly known as the FTCA. This is essentially the legal mechanism that allows private citizens to sue the United States government for wrongful acts committed by federal employees acting within the scope of their employment. It is one of the few ways ordinary people can seek compensation when the federal government causes them harm. But the government did not simply accept responsibility. Instead, the Department of Justice invoked what is known as the discretionary function exception. This is a provision within the FTCA that essentially shields the government from liability when its employees are making decisions that involve an element of judgment or choice, particularly when those decisions are grounded in considerations of public policy. The government's argument was straightforward in its audacity. They claimed that the planning and execution of the raid involved numerous discretionary decisions by the agents: how to approach the home, what surveillance to conduct, how to navigate to the location, how to execute the entry, because these were all judgment calls. The government argued the entire operation fell under the discretionary function exception. Therefore, according to the DOJ, the family could not sue, case dismissed. And initially that argument worked. The lower court sided with the FBI and the federal government, agreeing that the discretionary function exception applied and that the case should be thrown out. The family's pursuit of justice appeared to be over before it even really began. But this family did not give up. They pushed their case higher, and in a development that surprised many legal observers, the Supreme Court of the United States agreed to take the case. What the Supreme Court did next was remarkable, not just for its outcome, but for its unanimity. In a 9-0 decision, every single justice on the court agreed that the lower courts had gotten this wrong. The Supreme Court made a critically important distinction that cuts to the heart of government accountability. The justices stated clearly that law enforcement officers do not receive automatic immunity simply because they exercise some form of judgment during an operation. That is not how the discretionary function exception works. For the exception to apply, the government must demonstrate that the specific decisions in question were actually grounded in legitimate policy considerations. Making a mistake is not the same as making a policy judgment. Exercising poor judgment is not the same as exercising protected discretion. The court essentially said that you cannot take every operational failure, slap the label of discretion on it, and claim immunity. There has to be a real connection between the decision and an underlying policy objective for the exception to kick in. With that ruling, the Supreme Court sent the case back down to the 11th Circuit Court of Appeals with instructions to apply the correct legal standard. And that brings us to what just happened this week. The 11th Circuit held new oral arguments in this case, and based on the reports from those proceedings, the questioning was intense, pointed, and deeply skeptical of the government's position. The judges on the panel zeroed in on a fundamental question that really defines this entire case. Where exactly is the line between a protected policy decision and a basic operational failure? Multiple judges pressed the government's lawyers hard on this distinction. One of the central questions kept circling back to the same incredulous point. How can going to the wrong house possibly be characterized as a policy decision protected by immunity? The warrant had an address on it. The agents were legally required to execute that warrant at that specific address and no other. Getting the address right is not a judgment call. It is the absolute bare minimum foundational requirement of executing a search warrant. You do not get to exercise discretion about which house to raid. The warrant tells you which house. You go to that house. Full stop. The judges also expressed serious concern about the broader implications of the government's argument. If raiding the wrong house qualifies as a protected discretionary function, then what operational failure would not qualify? Under the DOJ's theory, virtually any mistake made during any law enforcement operation could be retroactively reframed as a discretionary judgment call. One of the judges articulated this concern directly during the proceedings, pointing out that almost everything a person does involves some element of choice or judgment. If the government's rationale is followed to its logical conclusion, then the discretionary function exception would swallow the entire Federal Tort Claims Act whole. Nothing would ever be actionable. The government would have near total immunity for virtually any operational failure, no matter how negligent or harmful. The judges also repeatedly pressed the government to explain how their current position was consistent with what the Supreme Court had just said in its unanimous ruling. This is where things became particularly uncomfortable for the DOJ's lawyers. By multiple accounts, the government struggled significantly to articulate a coherent answer. They could not clearly explain how arguing that wrong house raids are discretionary functions aligns with a Supreme Court opinion that specifically says mistakes are not automatically protected just because judgment was involved. Despite this pushback, the DOJ essentially doubled down. They maintained that every aspect of the operation leading up to the raid, the surveillance, the navigation, the execution plan, involved discretionary decisions. And because no specific federal regulation dictated the precise method by which agents had to verify a physical address before executing a warrant, the government argued that all of those verification steps fell within the agent's protected discretion. At least one or two judges on the panel appeared thoroughly unconvinced by this reasoning. The pushback was substantial. Several judges seem to draw a clear line between the how of executing a warrant, which might involve legitimate discretionary decisions about tactics, timing, and approach, and the where of executing a warrant, which is dictated by the document itself and leaves zero room for discretion. On the other side, the lawyers representing the family made what was described as a much simpler and more compelling argument. They told the court that this case is not about policy, it is not about tactics, it is not about the complex judgment calls that go into planning a law enforcement operation. This case is about a basic non-discretionary duty. When you have a warrant, you go to the address on that warrant. That is not a judgment call. That is not a policy decision. That is the absolute minimum requirement of lawful warrant execution. Getting the right house is not optional, it is mandatory. And failing to do so is not an exercise of discretion. It is a failure to perform a fundamental duty. By all accounts, this argument landed squarely with the panel. The simplicity of it seemed to cut through the government's more convoluted reasoning. At least one or two of the judges appeared to be clearly aligned with the plaintiff's position. Based on the tone and direction of these oral arguments, several potential outcomes are emerging. The most likely scenario is that the 11th Circuit rules against the government and allows this family's case to proceed to trial on the merits. This would mean the family finally gets the opportunity to present their full case and seek compensation for what happened to them that night in 2017. There is also the possibility that the court issues a narrower ruling, one that does not attempt to comprehensively define the outer boundaries of the discretionary function exception, but makes abundantly clear that this particular type of error, executing a warrant at the wrong address, does not qualify for immunity under any reasonable interpretation of the law. An interesting procedural development also emerged at the end of the arguments. One of the judges raised the question of whether the parties would be willing to submit entirely new legal briefs to the 11th Circuit, given that the district court below never had the opportunity to evaluate this case under the new standard established by the Supreme Court's unanimous ruling. Both sides indicated they would be open to additional briefing if the court requested it, but both also expressed their belief that the panel had sufficient information to rule on the matter immediately without further delay. The court indicated that if additional briefing is desired, the parties would be notified within approximately 1 week. This procedural choice itself could be significant. If the court requests new briefs, it may signal that the judges intend to eventually reach the substantive merits of the case in a thorough and detailed written opinion, which would carry even greater precedential weight. The stakes of this case extend far beyond one family in suburban Atlanta. The question at the center of this litigation touches every person in the country. Can the federal government claim immunity when its agents raid the wrong home? If the answer is yes, then federal law enforcement operates with an almost impenetrable shield against accountability for even the most basic operational failures. If the answer is no, then there remains a meaningful check on government power, a way for ordinary citizens to seek justice when the government causes them serious harm through negligence. A 9-0 Supreme Court ruling already signals where the law is heading. The 11th Circuit oral arguments this week strongly suggest that the appellate court is prepared to follow that signal. The government's attempt to stretch the discretionary function exception to cover wrong house raids appears to be failing, and failing decisively. This family endured something no one should ever have to experience. Their home was invaded, their safety was shattered, their child was traumatized, and for years afterward they were told by their own government that none of it was actionable in court. The Supreme Court disagreed unanimously, and now the 11th Circuit appears poised to deliver that same message. As soon as the court issues its decision, the full implications of this ruling will become clear. This is a case worth watching closely, because its outcome will shape the boundaries of government accountability for years to come. That's it for today, folks. See you in the next video.